5, 4, 1.
Please rise and join us for the invocation, please. Invocation by Member Johnson.
Heavenly Father, as we gather here for this hearing, we ask that your presence fill this room. Grant us clarity of thought and purpose as we seek to make decisions to honor you and benefit all. May our efforts lead to great success, and may we always rely on your guidance in all we do. In Jesus' name, amen.
Calling to order this meeting of the Cumberland County Board of Elections on August 12, 2025, 1 o'clock p.m., sitting today as a hearing panel in a candidate challenge. Please join us for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I just want to remind everyone who's here today that we'll have to be quiet when we're going to be hearing testimony, and it's important that everyone, it's a very full room, very quiet room, and if we start having side conversations, it'll make it difficult for not only the members of the panel to hear the testimony, but as well for this meeting is being recorded, and it is important that the recording be able to pick up everything that's said here today. So I thank you for that in advance. Is there a motion to approve today's agenda?
So moved.
Is there a second?
Second.
Any discussion? If not, I'll ask for your vote. All those in favor of approving the agenda as presented, please indicate by saying aye.
Aye.
Any opposed? And that is unanimous. Thank you for your vote. Today's hearing is a quasi-judicial hearing. Our board members are sitting as a hearing panel today to hear testimony and evidence and apply the laws of North Carolina to the facts that we will hear. Our decision will be based upon a preponderance of the evidence, which is based on the record taken as a whole. Our vote will be by majority vote of board members, and there is a right of appeal to the State Board of Elections for the non-prevailing party and any candidate adversely affected by our decision today. With that, we'll start the process. The hearing today, and I want to remind you, is open to the public, and it will be recorded by audio and video. We'll hear opening statements now from the challenged candidate and the challenger. Will each be permitted 3 minutes, a time not to exceed 3 minutes. After the presentation of the evidence, and the challenge candidate and the challenger will be permitted to offer closing statements not to exceed 2 minutes. This proceedings document has been provided to the parties ahead of time, and they're aware of this. Let's start, therefore. Yes. Yes, everyone, please turn off your devices. Thank you, Helen. Helen is the county attorney assisting us today. Do I need to read the challenge document, or is that going to come in as evidence?
I think that you could read that, and are you allowing the protester to go first?
No, the burden of proof and the first person to give their opening.
I meant to say the candidate.
The candidate, yes. Yes, ma'am.
So if you want to put on the record what the protest is, the challenge is, so that way when he comes up, he can
To frame it. Okay, thank you very much. I appreciate that. I am not placing this in evidence right now, but I will give a preview by reading the challenge, the pertinent part of the challenge that we're considering today. The above named candidate does not meet this is the challenge, reading from the challenge document. The challenge document says that the above named candidate does not meet the following constitutional or statutory qualifications for office, did not complete the answer correctly for being convicted of a felony on the candidacy form. This challenge is based on reasonable suspicion or belief of the following specific facts. This is the allegation contained in the candidate challenge, that Murillo pled guilty to a felony, assault and battery first degree on January 10th, 2012 in Horry County, South Carolina, and that per North Carolina statutes, it is a Class 1 felony to complete the form knowing that information as to felony conviction or restoration of citizenship is untrue. And with that, the candidate has the burden of proof in this, and he will go first in presenting his opening statement. Mr. Murillo, are you here?
Yes.
Are you represented by counsel today?
No, ma'am.
Okay, it's up to you then to make your opening statement.
Yes. Thank you.
Please approach the mic and
Good morning.
Hold tight, sir.
no clapping. You're going to have to be silent. We need
Sir.
to hear everything that's said by those who are speaking to us and providing evidence and testimony. And I believe Mr. Edmonds is going to be our timekeeper.
I will be at 30 seconds left. I will. All right.
Okay. I have supporting documents if I can hand out to the panel.
You can present evidence, but this is your opening statement. You
Okay.
can later present
Madam Chair,
evidence.
You need to make sure that it's a quasi-judicial hearing, so they need to be affirmed or sworn.
But not for opening statements.
I would suggest you affirm or swear.
Okay,
everybody, so
let's go
there's
ahead and
no
do that.
question.
There's a Bible there for you, Mr. Murillo. I'll go ahead and just in case any of the statements you make during your opening statement you intend to rely upon as evidence in this hearing. Do you swear or affirm that the testimony you shall give to the board shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can proceed with your opening statement. You have 3 minutes.
So I'd like to say welcome all. Thank you all, city officials in attendance. Ms. Green, if you're in attendance. I want to thank all who took the time out today to attend. It's been an interesting 3 weeks. Since then, I have been threatened through my family and friends. Also, I was told that some local politicians and businesses were also affected. The people responsible belong to associate with the Fayetteville Resistance Coalition. People have been harassed on social media platforms. There was an incident brought to my attention last night that a young female was out with her partner and was harassed by one of the FRC solicitors. This is an example of what these people do in pursuit of ignorance. I can admit where I was wrong, and I was looking at my record, and I would too question myself. I've done so many things as a different level combat veteran. Physically and mentally, I've gone through some hard times. If they put forth the effort to pursue me as they would to making this city great again, then we would be in a better place than we are right now. I knew for a fact that if I was a felon and I would have checked felon, it would not have hindered my, opportunity to run, as we have felons in office. So therefore, my understanding is I am not a felon. I have the documents to prove this, and I look forward to presenting them to you guys. So thank you.
Thank you, Mr. Murillo. No clapping. I'm sorry. We will have order. The challenger now has an opportunity to present her opening statement, and Ms. Hatcher, I will go ahead and swear you in at this time as well. Do you swear to or affirm that the testimony you shall give to the board shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may begin. 3 minutes.
Good afternoon. I'm Aline Hatcher. I'm a resident of Fayetteville, North Carolina, and I reside in City Council District 5. I am formally challenging the candidacy of Enrique Roberto Murillo for Fayetteville City Council because he did not meet the statutory requirements under North Carolina General Statute 163-106 when he falsified his notice of candidacy by stating that he had never been convicted of a felony crime. Thus, he should be disqualified from running in this city council race under North Carolina General Statute 163-127.2. On July 16, 2025, Mr. Murillo filed a notice of candidacy for Fayetteville City Council at the Cumberland County Board of Elections, affirming under oath that he has never been convicted of a felony. As the evidence will confirm, Mr. Murillo was both arrested for and indicted by the grand jury for criminal sexual conduct, 3rd degree, after being accused of using force while committing sexual battery, a felony under South Carolina Code 16-3-654. He ultimately pled guilty to the lesser offense of assault and battery 1st degree, also a felony under South Carolina Code 16-3600. On the same day, the solicitor filed an order lifting the bench warrant from Mr. Murillo's arrest for failure to appear on October 7, 2011, stating the defendant has been tried and found guilty and/or pled guilty on the pending charges. The South Carolina court then sentenced Mr. Murillo to a 3-year suspended sentence and 1-year probation. North Carolina Statute 163-106 establishes a requirement for filing a valid notice of candidacy for elective office. North Carolina law clearly states that in order to appear on the ballot, a candidate must meet the constitutional and statutory qualifications for the office sought. This includes not only eligibility criteria such as age, residency, and notice of felony conviction, but also presumes the requirement that the notice of candidacy be completed truthfully and in full compliance with state law, thus the requirement for the oath. Submission of materially false information voids the statutory integrity of filing process. The statute says that each candidate shall file a statement answering the following question: have you ever been convicted of a felony? The statute explicitly states it is a Class I felony to complete the form knowing that information as to felony conviction is untrue. Mr. Murillo pled guilty in 2012 to a felony charge in South Carolina. Despite this, Mr. Murillo marked no in response to the question, have you ever been convicted of a felony? This misrepresentation is not trivial, is a material falsehood under oath, and therefore disqualifying act under Statute 163-106. By knowingly submitting false information, the candidate has not completed the statutory process required to qualify for candidacy, and he should be disqualified from this municipal election.
Thank you, Ms. Hatcher. We will now proceed to the presentation of evidence. The challenge candidate will have the first opportunity to present evidence. The challenge candidate has the burden of proof by a preponderance of the evidence in this case to establish the facts relevant to his being qualified as a candidate, which in this case will be on the issue of felony conviction. Mr. Murillo, do you have any other witnesses you plan to present other than your own testimony?
No, ma'am.
Do you have any documents you want to enter into evidence?
Yes, ma'am.
You'll need to present those. Have some. You can start with the county attorney.
There's a copy for everybody here.
Yeah, just pass it down, Will.
Is there just one package? One package? Or-
There's 5 packets in there. So in this pack, are you ready for me to start?
Let's get our copies first.
All right.
Anyone else need?
Some additional copies here.
I need one.
Okay.
Just gave you.
I'm sorry.
Uh,
If you could pass the one, I gave mine so that.
That's yours.
Pass it back this way.
Did the challenger get a copy as well?
I did.
Ready? In this packet, you'll find, of course, it's for the Board of Election members, subject myself, tabs A through E. Tab A covered the North Carolina Notice of Candidacy by Petition. B covers your Horry County 15 Judicial Circuit Public Index. Subcategory 1, case parties, the state of South Carolina versus Enrique Murillo.
What page you're on, sir?
I'm just going to go through the tabs first, and then I'm going to go through the pages. The charge code description, the original charge code, the original charge was sub 3, sentencing, sub 4, actions, 5, financials, 6, bonds. Tab C, North Carolina Department of Adult Correction letters, Josh Stein, Governor's Office. Sub 1, probation supervision fees. Tab D, South Carolina 217, General Session sentencing sheet. Tab E, South Carolina definition, lesser included offense boxes checked. Tab E. All right, we'll go to A, North Carolina candidacy petition. So as you see right down there, it says, I hereby file notice candidate for election to the office indicated in section 1 on this form. I swear or affirm that the statements on this form are true, correct, complete to the best of my knowledge or belief. To the best of my knowledge or belief. That's what I would like to highlight.
Mr. Murillo,
Yes.
the panel has the opportunity to ask you questions as well.
Okay.
And I would like to ask the relevancy of this form, since I don't believe that you, your candidacy filing was by petition.
Nope.
I believe you gave a notice of candidacy, but not by petition.
Okay. That's all right. I was
Yeah,
just
but
going
we-
over what
we
I
have
signed.
We have his original.
I'm
form.
just, he's referring to the form he provided to us.
I was just referring to the form where I signed and where I checked the block non-felon, ma'am.
I'm just saying this is not the form that you signed. You signed a notice of candidacy, but not by petition. That's the only distinction I'm trying to make.
Yes, ma'am, understand. Tab B, B2, goes over the charges. Original charge code, original charge, sex, criminal sexual conduct, third degree. Charge code, charge description, the actual charge that it was dropped down to. Assault, assault and battery, first degree. Move to the sentencing sheet, which is tab D.
Give us a chance to catch up, sir.
Yes.
Okay.
Okay. On this sheet, you'll see my name, my signature, the charge, first degree assault. Underneath that, it's a block check, nonviolent. Below that, there's a block check, lesser included offense, in accordance with section 16-3-600. So that is your general session sentencing sheet. If you move forward to,
Can I stop you for just a second, and
Yes.
perhaps you can explain that to us a little more?
so yes, so that's what tab D, D3 will explain what that actually means. Lesser included offense, that block was checked. So if you go to tab D, D1, move down to D3. Assault and battery in second degree is a lesser included offense of assault and battery in the first degree, as defined in subsection C1, assault and battery of a high and aggravated nature, as defined in subsection B1, and attempted murder as defined in section 16-3-29. So that explains what the charge was brought down to, nonviolent, and then the block that was checked was lesser included offense. And in that, right there, D3, explain what lesser included offense means.
Sir,
Second degree,
may I stop for just a second?
yes.
My understanding of a lesser included offense is anything less than the original indicted charge.
From the understanding, it's lesser than what is agreed on the pleas deal, and that's why it's brought down to second degree misdemeanor assault. If you move on to tab E, on a South Carolina form, SCCA/217, when the lesser included offense box is checked, it means that the defendant is agreeing to plead guilty to a crime that is less serious than the original offense which they were charged. So you have the original charge, then you have the charge that was plead to, and because the block was checked of lesser included offense, that's what it brought it down to, ma'am.
Sir, lesser included offense, if you read the statement you just read to us, it means that the defendant is agreeing to plead guilty to a crime that is less serious than the original offense for which they were charged. You were originally charged with the sexual assault charge. The lesser included offense you pled guilty to is stated on the forms you've provided for us to be assault in the first degree, a felony.
Yes, that is understandable, but we are going based off of that sentencing charge. And that's what I'm basing this off of. Now, if we take a look at the punishment on tab E1, a person who violates subsection is guilty of a misdemeanor upon conviction must be fined not more than $2,500 or imprisoned for not more than 3 years or both. If you take a look at first degree assault felony charge and the punishment that was handed down of 3 years suspended, 1 year probation, and a fine of $640, I believe. The crime does not match the punishment. The punishment does match a second degree misdemeanor crime, and that is stated in there. And I would like to address also the fine cost of $6,000, tab C. So there's a letter in there from the probation office stating that it was their error why I accrued a $6,000 charge. The person who originally handled my probation did not close it out right. When you close out a probation, only way you can close out a probation is if you pay all your fines and your probation is still open. So that letter states, it has come to my attention that you were previously on 12 months of supervised probation, case number 12PR090003, out of the state of South Carolina, assigned to our department in 2012. At the time your supervision ended in 2013, you had unpaid balance of $330 in probation supervision fees. Due to an error, the case remained open, resulting in the continued accrual of supervision fees totaling $6,080. As of this date, your case has been adjusted to reflect the remaining unpaid balance of $330. To pay the balance in full, you can contact Cumberland County Clerks and provide listed case number. Next page is the receipt for that $337.89.
And the date of that, sir?
The date of that believe it was last Friday, 6/7,
Yeah, I think it said August 7th.
August
August
7th,
7th.
August 7th, right
Thank
up
you.
there at the top.
Thank you, sir.
That's all I have. Do you have any questions?
Panelists, do you have any questions of Mr. Murillo?
Thank you for the presentation, Mr. Murillo. I believe I will have a couple questions after Ms. Hatcher comes up, so stay somewhere close to the aisle,
Okay.
okay?
Do I get asked my questions at that time too?
One, are you accepting the documents he gave you into evidence? And number two, just so that we can continue to conduct this as a quasi-judicial hearing, you should only address the chair or the board when they address you. She will follow her procedures, but you shouldn't speak out. You should allow them to control. She knows what her tasks are, and she'll do that. If at such time that you are overlooked, I would suggest you raise your hand to not interrupt and then be recognized.
Thank you. The document we have in front of us has been presented as evidence by the candidates. The question that a county attorney is posing is whether we accept this into evidence. What is your advice?
Well, he's presented it, so you would just simply accept it as the candidate's exhibits
I
or
guess what I'm asking is
evidence.
because we're sitting as a panel rather than as one person. Do we do that as a vote of the panel, or do we do that just as a decision of the chair?
You can do it as a vote of the panel, but most of your decisions will be a vote of the panel.
Okay.
And
So
then the chair, of course, recites what that decision
is
is.
there a motion to accept the packet that was presented by the candidate?
So moved.
Is there a second?
Second.
Second? Is there any discussion of that? If not, I'll ask you for your vote. All those in favor of accepting this piece of evidence indicate by saying aye.
Aye.
Any opposed? That is unanimous, and the evidence is accepted. Thank you. Thank you, Mr. Murillo.
We can't hear you. Yeah, we can.
You can't hear me?
Okay.
Are we turned on?
Yeah, I think we need to speak into the microphones more. Yes.
And generally, the microphones are for recording purposes, not necessarily for volume.
Okay.
Okay.
So we'll just try to speak loudly and clearly, and you all are doing a good job of being quiet in the background. That would be very helpful. We appreciate that. Ms. Murillo, you have no other evidence or witnesses that you want to present?
Madam Chair?
Yes.
Did you have questions for him?
Yes.
Okay, he needs to return.
You need to return, and remember that you're still under
Yes.
oath. Panelists, do you have questions of Mr. Murillo?
I do have one.
Well, you need to ask.
Mr. Murillo, as far as you are concerned, you have completed your parole and probation and paid all of your fines?
Yes, that was completed back in 2012. The error that was stated there was brought up due to investigative people, and we went down to the clerk office when it was brought up originally to the Board of Election, and the clerk office had no indications that I owed them money until the
Okay.
people started doing the digging. And then we did, which we cleared it up that it was their error, and we took care of that.
And then my other question is, and I'm not quite sure about how to read this. The notice of candidacy form says, have you ever been convicted of a felony? And I followed your presentation, but can you in kind of plain language explain to to us why you checked the no form, the no box?
Because when I remember doing this back in 2011, trying to get the case move on with my life, the attorney, my public defender, said, hey, we can get this going. The witness isn't here. You know, she probably won't be here. It's been about our third case. And he said, well, we can plead you out, you know, rather than if I would have known back then, I would have just took it to trial and it would probably ended that way because she wasn't present. But I said, hey, I don't want anything on my record. I don't deserve to have anything on my record. This is what I would like to agree to. And he threw out second-degree misdemeanor assault. And I agreed to that. And that's what I've been traveling with for my life, according to them, since then. So I do not consider myself a felon based on my belief of what happened back in 2011, 2012.
Okay, so if I'm understanding you correctly, you didn't think you were a felon?
I know, according to this, I am not a felon.
Okay, okay. All right, thank you.
Yes.
Question?
That's all I have.
I have a
I think
question.
I have one for the county attorney, Ms. Helen, Ms. Nixon. You've looked at this.
I cannot make any decisions on that. Your board, the only thing I could give is legal guidance if you're off course, but I can't help you make any decisions. I can't look at the documents and say, yes, he's a felon, no, he's not a felon. Those issues of determination are left for you, the board, to decide.
That answers my question, and thank you, ma'am.
I have a question.
Go ahead.
Mr. Morello, when you were with your attorney, did they specifically state to you when you pled to this lesser charge if it was or was not a felony? Did they specifically
Yes.
tell you?
That was the agreement that I remember making with my attorney. I did not want a felony charge. I wanted to pursue military contracting at the time, and that's not something you can pursue being a felon.
Okay.
You know, and I
So,
have been military contracting. I do have access to certain things that I believe a felon would not have access to.
okay, so he specifically told you
Yes,
it
ma'am.
was not a
Second-degree
felony?
misdemeanor is what I remember and what I agree to.
Okay.
So you did speak also with the judge.
Yes, we do, and we're awaiting those transcripts.
You will.
So that's one thing that we want to verify is with the transcripts. So yes,
And you have any recollection of what the judge said?
from what I understood, was second-degree misdemeanor, sir. That's it.
Okay.
Mr. Murillo, first of all, I'm looking at a document which has not yet been entered into evidence. It's South Carolina Code, Article 7, assault and battery, definitions and degrees of offenses. It matches the charge code that is on the document you provided as tab B2, charge code. The original charge being criminal sexual conduct, third degree. What you pled guilty to, according to this document, is assault and battery in the first degree, which is a felony under South Carolina law. That's what this document says. That, in fact, is a lesser included offense of the offense you are actually charged with. So I'm trying to understand why you think that this document is either an error or that you misunderstood it. Could you explain for us?
I'm just going with what the document says and what my perception of the document is, and through legal advice counseling, is that what the document says. It's lesser than the charge that's stated on there, which constitute the punishment matches a second-degree misdemeanor. It does not match a first-degree assault and battery. So therefore, the statements are all lining up with that. And, you know, for a first-degree assault and battery, you know, to get 3 years suspended probation, 1 year probation supervised, and just court fines, just seems kind of less for what the charge is. So unless South Carolina allows that to happen, I don't believe North Carolina will. But that's where it is, where the crime doesn't fits the punishment. And that's how we match that based on the sentencing sheet as well. Nonviolent, lesser charge.
Well, it is a lesser charge than what you were indicted for. You were indicted for criminal sexual conduct, third degree. The lesser included charge that you pled guilty to, according to this document that you've given us, is assault and battery in the first degree, which is a felony under South Carolina law.
Yes, you've said that before, and I've addressed that question again before, ma'am, and that's the same thing. Same response is what I have.
Okay. Are there other questions?
No, I don't have
That was
any more.
my question. Thank you.
Thank you.
Thank you.
The burden of proof in this case, did you want to speak?
So the challenger has asked to ask questions of the
She
candidate.
may do that. Would you return, Mr. Morella, please?
I
The challenger
have-
has, what?
I have a question of the challenger.
Well, you have to wait till she's
She
sworn in
hasn't
and presents her
on hers.
case.
Okay.
The challenger is acting as her own counsel today, and she's going to question the witness.
And I don't know if you want to provide rules to her in regards to her questions.
Does she need a microphone?
I'm not sure what you mean.
Do you want to set a number or a time limit in terms of how long she may question or make sure that the questions are pertaining to what's before the board right now?
Right. The question should pertain to the elements of this case and to the testimony that's been presented up to this point.
Correct. I'll make relevant testimony.
You putting the time
Ms.
limit on?
Morel, when you were convicted of a DWI-1, did you receive 3 years in jail and pay $4,000?
That is not relevant to what we're talking about right now.
What, as far as testimony, my question was going to be, did you think it was odd that you received a
So-
lesser sentence than the maximum?
Hold tight, ma'am.
DWI.
Okay, so one, she should be addressing what she
What's
filed her
been-
protest in regards to.
So,
I was going on his testimony, he said it was odd to get a lesser sentence.
so you'll have an opportunity to present your challenge later on. But at this point, if you'll just address his testimony, and if you can tie it into his testimony, please make that preface before you ask the question.
Okay.
And then also it should be a question, not a statement or a
Correct.
testimony.
Ms. Morel, did you think it was odd on a different conviction to receive a lesser sentence?
I'm sorry, Ms. Hatcher, but that's not what you're referring to is not in evidence.
Okay. Okay.
You'll have an opportunity to do that when it's your turn to testify.
Okay, so on your arrest warrant in 2011, it states that you reside in North Carolina. Have you resided in North Carolina since 2012?
Yes.
Have you voted in any federal, state, county, or municipal?
That
elections
has
since
nothing
2012?
to do with,
Yeah. What's the relevance of
There's a
that?
Supreme Court decision about there's a Supreme Court case, if you think you
But
didn't
that
have a
has-
felony, to prove that you were able to do things that you could do with a felony. Yep. I have a case if you like it.
It's relevant, go ahead, you may proceed.
Yes. Well, I have not registered to vote. I am now registered to vote. So, I mean, if I am not eligible to vote, it would have came up.
But you didn't vote, so.
No, I've never voted because I was in the military and did not.
Do you have a concealed carry permit?
No, I do not.
Do you own a firearm?
No, I do not.
And then again,
what does that have to do with?
So this is-
I'm happy to give you a Supreme Court
So,
case.
please, it's that
I understand it's relevant. Whenever she finished the question, I understood the
Yeah,
relevancy
okay.
of it.
Have you purchased a firearm manufactured after 1900 since your conviction in 2012?
Nope.
Okay. Have you ever had a concealed carry permit?
Yes, I had.
And did you lose your concealed carry permit?
I don't believe I did.
Have you
No
ever owned a
notice of that?
firearm?
Yes, I did.
Have you ever lost your firearms?
Nope.
So, but you don't own any firearms currently?
I don't. I gave away my weapon that I had back in 2008 to my daughter's godfather. So he has that weapon now.
Okay.
And I was still in the military at that time.
And you stated, so just question, you have military clearance that you would only get if you have a felony?
Say again?
I was just quoting testimony, so you have military clearance that you would only have.
Say I have
if you had
access?
not had-
Yes.
If you did not have a felony.
Is exactly, ma'am.
Okay. Thank you.
I have one question, but Mr. Murillo, as a follow-up. When did you separate from the military?
2011 June.
Okay, so when you said you haven't voted, you meant since 2011 you haven't voted?
Yes, ma'am.
Okay, thank you. And since this conviction?
I have not, yes.
Yeah, thank you. Thank you. Ms. Hatcher, you as the challenger can present your testimony and call any witnesses or offer any evidence.
Okay.
You just went around.
So,
I need to swear you,
I think that's where.
we did that.
Yeah.
She's sworn.
she did.
She was sworn.
We
when
did her.
she gave her statement.
So I brought my exhibits. The statute said you had to also bring certified copies. I couldn't get enough certified copies, but here's the original certified copies if anyone needs those.
Well, we need to see the evidence.
Okay, I've got them right here. So here's Exhibit A. This is the arrest warrant.
We'll do these one at a time if you only have one copy of
So
each.
this is the arrest warrant M348938 dated April 23rd, 2011 for Mr. Murillo for criminal sexual conduct, third degree. This is the grand jury indictment, docket number 2011, General Statute 2011-GS 2602276, dated June 30, 2011, for Enrico Robert Murillo for criminal sexual conduct, third degree. This is Exhibit C, South Carolina Sentencing Agreement. That's Form SCCA-217, dated January 10th, 2012, for Enrique Robert Murillo for assault and battery, first degree. South Carolina Code 16-3-0600, South Carolina CDR Code 3412. This
Could you
is,
explain again this particular document to us?
that's a sentencing document,
Thank you.
okay? And this is, again, I have a certified one that's sealed and everything that I drove down to South Carolina and got.
I understand.
Okay.
So the copies you're presenting to us as panel members are a courtesy as well as to the defendant, but you have the original documents you want
I do.
entered in-
The statute said you had to have a certified copy of everything, so I drove down and got it.
entered into evidence. That's what
Correct.
I'm saying.
All right. This is Exhibit D. This is the South Carolina order lifting the bench warrant for Eric Murillo, dated January 10th, 2012. Mr. Murillo in his testimony stated that the defendant was a no-show. I think this bench warrant will show you that he had an arrest warrant for him for being a no-show. This is Exhibit E. This is the South Carolina code. If you'd like the code that's related to the sentencing sheet. This is Exhibit F. This is a CDR code reference on the sentencing sheet that shows you where it's felony.
And I would ask if you would just label those because they're not labeled.
And I have a sheet if you'd like that'll tell you what they are. This is Exhibit G. This is the Horry County Public Index. This is available to anyone in the public where you can index the record. This is Exhibit H. This is the financial information that Mr. Murillo referenced earlier, where he had a fine. He had a fine where he was supposed to pay $40 a month for his supervision of his out-of-state probation. His fine was corrected. They were charging him for every month instead of the 12 months he was under probation, so they did correct it. However, he didn't make restitution to make this payment to correct this probation fine until after the deadline to file. So here's the paperwork for that.
Sorry.
And then lastly, I have a search from the North Carolina Board of Elections for voter registration, showing that Mr. Murillo registered to vote on the day that he signed up to run for the campaign, and that he has no election history prior to that in North Carolina.
Is that all your documents?
Yes, ma'am.
I would entertain a motion to accept these documents into evidence.
So moved.
Is there a second?
Second.
Ask for your vote. All those in favor of accepting the documents into evidence? Yes, ma'am.
Have you received certified copies?
She has the certified copies for the record.
I understand. Have you received the certified
Do
copy
you
into
want
the
her to
evidence?
pass those as well? Thank you. So we want to review just the certification of these before we accept the originals into evidence.
I have a couple of questions for Ms. Hatcher when you're ready.
Absolutely.
Okay.
You have to know what he was planning when he planned to. Something.
While we're waiting, Ms. Hatcher, could you identify to us which of the exhibits are by certification and which are public record?
Sure. So you have a receipt there for Exhibit A, Exhibit B, Exhibit C, Exhibit D. And per South Carolina, they place a stamp on C when they certify a sentencing agreement, so it has like a notary stamp as well,
Understand?
as well as the receipt. And I think that I gave you, also sent through the original copy of the correction to his, I may have sent through the first sheet, but this is a sheet from the clerk of court in Cumberland counties. Also, I think I sent the first, this is like the first sheet, I think that's, actually I sent the second sheet, not the first sheet. Where I got that directly from the clerk of court, it's stamped with their name as well, where showing that they corrected his fees.
Yes.
So that's Exhibit H.
I'm ready whenever you are.
Fine.
So Exhibit G is from a public search, and Exhibit I is from a public search, as well as E and F.
Thank you. Thank you for that clarification. Our panel members ready to take a vote on accepting the certified and public documents
Yes.
as evidence?
Yes.
All those in favor, please signify by saying aye.
Aye.
Any opposed? That's unanimous. Thank you for your votes, and you may proceed, Ms. Hatcher, with your testimony.
I'm finished with my evidence.
Okay? Thank you very much. I appreciate it.
question.
The candidate has an opportunity to cross-examine Ms. Hatcher if he chooses, not cross-examine, but ask questions of. If he chooses, as do the panel members.
I do have a couple questions.
Okay.
It wasn't quite clear to me from the challenge form. Are you contesting his candidacy because he lied on the form, or are you contesting his candidacy because he has not completed his obligations following his conviction?
So I don't think that he's completed his obligations, but I'm not an attorney, so I don't know what the rules are on that and restitution. However, I am contesting that he did not, his answer is false to whether he's been convicted of a felony.
Okay, so your contention is that he was not truthful when he completed the form?
Correct. I am not saying that he also, not completing his restitution did not complete his probation, but I don't know what the laws on
Yeah, and-
that are that, so I'm not gonna make a contingent on something I don't know the
Yeah.
laws on.
And I'm not, our guidelines are very different for when you are contesting that he lied on the form versus when you are contesting that he did not complete his parole or probation or restitution. So that's why in order for me to make a decision on how to proceed, I need to know which you are
So
contesting.
again, I'm giving you both information at the time I filed the
Challenge?
he had a bill, an invoice that said he owed $6,000. And I will be upfront with you and tell you that did not look correct to me. Something looked off. I mean, I just couldn't imagine that they would let $6,000 go. So I didn't want to file a challenge on something that I didn't think was correct.
Okay.
So I'm not sure what Mr. Murillo did. I also notified the clerk of court's office that I thought something was wrong with the form.
Okay.
And so I followed up, and those copies that you have are where I followed up and saw that the amount was corrected before he paid it. So if you'll check the dates, you'll see I got a copy when it was corrected, and then I got a copy after he paid it.
Okay, but your challenge, I'm not trying to put words in your mouth. Your challenge is based on the
By the
fact.
form, I was not, you're gonna have to go based on what I put on my form. right? So you're
Right.
going to have to go.
And that's what I'm trying to clarify.
So my form says that my challenge is based on the fact that he did not fill out the form. He did not answer the question
Correct.
truthfully.
Okay, okay. Thank you. That's
I
all.
don't think I can add another challenge now.
Okay.
Mr. Murillo, do you have any questions you'd like to ask of Ms. Hatcher?
I think he had to subpoena me to ask me a question.
No, he doesn't.
Are you sure about that?
So it does say that if a person, she would have to be subpoenaed. However, she's already subjected herself to questions of the board. So I would suggest then she's opened the door and allowed an opportunity for him to question as well.
I specifically think the statute says in order for the candidate to ask the challenger questions, that must be subpoenaed. I'll pull it for you.
I did highlight this somewhere.
The order of proceedings that we provided to the candidates specifically says that if a party is offering testimony from a witness, the witness will be sworn in by the chair of the panel. The opposing party will have an opportunity to cross-examine any witness who testifies.
Yes.
Okay, and did you read further down in what you sent me?
Yes.
Where it says about me being asked questions by him?
It's not addressed in the order of proceedings that you were provided.
Excuse me?
That is not addressed in the order of proceedings that you were provided.
Let me just make sure.
Okay,
It says
so-
evidence.
So it says the challenger shall be permitted to present evidence at a hearing, but the challenger shall not be required to testify unless subpoenaed by a party. And it says that the panel may allow evidence to be presented by the person who is present. She has gone beyond presenting the evidence. When she answered questions, that was testimony. So then that opens the door and gives opportunity for the candidate to ask her questions.
Entirely, I agree with you.
Okay, I'm happy to answer them. I just want to make sure that I note that I disagree by statute, so that
Okay.
for appeal.
Well, I think the county attorney's point is well
Okay.
taken, and we should take her advice on this, that once you became a witness and offered testimony, you're subject to questions by the
I
candidate.
think the statute says I have no choice but to answer your questions, but he has to subpoena me to answer his.
We'll agree to disagree on that point.
All right, go ahead.
I have no question.
Okay. That was good.
I love it when a plan works out.
I'll give you props for that.
Okay, thank you very much, Ms. Hatcher. Are there any other questions by the panel? So do you have anything to present to us on the issue of whether or not the failure of Mr. Murillo to have paid his costs for his supervision, which were a part of his sentence requirement, whether or not non-payment of those does not restore his rights as a voter in this state?
So again, there's different laws on that, so I think
Yes.
that's up to the board to make the decision. I'm not an attorney and not a judge.
Okay.
The panel did have an opportunity during this period to subpoena any evidence that you wanted yourselves or any laws that you wanted yourself, or, so.
We did. Thank you so much. I
Thank
really
you.
appreciate it, Ms. Hatcher. We appreciate both of you. If we are done hearing evidence from the candidate as well as the challenger, we will proceed to closing arguments. And each side will have time not to exceed 2 minutes. The challenge candidate will go first. and he has 2 minutes to argue his case.
Just want to say thank you. Thank you for hearing me out today. Really to make a closing argument. I submitted the documents from what I believe was as truthful, factual, and as honest as we can find. Upon finding out about this whole situation, I went down to Horry County myself, pulled the documents, looked at all that. As far as the fines, we went to the clerk office. They had nothing for us until, like I said, they investigated, and then all of a sudden that popped up. We took care of that. So I took care of everything that I needed to take care of. My knowledge, my best belief, I am not a felon since 2012. I've been carrying myself that way as straight as I can, as much as I can, and that's where I'm at. My question is, if I would have checked the block of being a felon, would Ms. Thatcher would have pursued all the good things and the great things I've done in the last years? Probably not. So therefore, I close my case. You have all the supporting documents, and thank you so much. God bless America.
Thank you, Mr. Murillo. Ms. Hatcher, you also have time not to exceed 2 minutes.
Yes, timekeepers on point.
Thank you. Mr. Murillo swore under oath on his notice of candidacy form that he had not been convicted of a felony. This statement is factually and legally false. By knowingly submitting false information, the candidate has not completed the statutory process required to qualify as a candidate. Presuming someone may consider it plausible that a judge, a prosecutor, a defense attorney, a North Carolina probation officer, a South Carolina probation officer, and officers involved in arrest for probation violations failed to inform Mr. Murillo that he had a felony conviction, ignorance of the law and ignorance of his felony conviction are not a defense. If ignorance is accepted as an excuse for false information, it will undermine our election system's integrity. This board is empowered to ensure that only candidates who meet all constitutional and statutory qualifications appear on the ballot. This includes disqualifying any individual who submits a false or fraudulent candidacy form. To allow otherwise would undermine public trust in the electoral process and violate the letter and spirit of North Carolina law. Based on all evidence presented here, I respectfully request that you determine that Mr. Murillo failed to meet the statutory qualifications for office by submitting a materially false notice of candidacy, disqualify Mr. Murillo from the current municipal election, deny any request to refile or submit a corrected notice of candidacy as a deadline has passed and no statutory authority allows such relief, refer this matter to the appropriate prosecutorial authority for investigation under NCGS 163-106. This is not about politics. It's about protecting our integrity of our elections, ensuring transparency, and holding all candidates to the same ethical standards. We deserve leaders who tell the truth. We deserve a process we can trust, and I call on you to do what is right.
Thank you very much, Ms. Hatcher. No.
All right, I have something.
So we are done hearing evidence. We've heard opening and closing statements. Our panel is now open to discussion.
Okay. So, I'm trying to be as tactful as I possibly can. I asked Ms. Hatcher specifically what her contention was, and she was very clear that she was contending the truthfulness of Mr. Murillo on the form, on the notice of candidacy. Do I believe that Mr. Murillo is an upstanding citizen? Not for me to judge. Do I believe he lied on the form? I do. Is the remedy for lying on the form disqualification for running from office? It is not. According to the State Board of Elections, we cannot disqualify somebody from running for office because they lied on a form. That is very clear in the guidelines we received. The question for me, and that may be something for our only licensed attorney in the room to answer, is Mr. Murillo,
There are actually two of us.
did Mr. Murillo, when he filed his notice of candidacy, had he completed his parole or probation? So does the fact that he paid his fines 2.5 weeks after the date closed, does that mean that he had not completed his parole or probation? And even then, since the contention of Ms. Hatcher is not that he was still an active felon, but that he lied on the form, which is something we are not allowed to disqualify him for, what do I do with all that?
Okay, so if I can find that document.
Okay.
If you'll go back to your,
Challenge procedure guide? Okay.
so you'll first have to look and see what information is necessary to determine that he was ineligible as a candidate.
Okay.
There were 3 things, I believe, listed on there. And it would be the candidate challenge procedure guide.
I'm looking.
So whenever you look at the guide, it tells you what he has to meet in order to be eligible. It says a person who files a notice of candidacy for
What
any.
page, please?
The front page, the first page, first paragraph. It says, for any elected office, may have his or her qualifications challenged by a formal complaint called a candidate's challenge. State law allows any qualified voter in the same district as the office sought by the candidate to challenge the candidate's eligibility for elected office based on the grounds that the candidate does not meet the constitutional or statutory qualifications of the office. So then, let's see. So once you go to the actual qualifications, and I might be able to pull it up quicker on my computer. When you go to the actual qualifications, a part of which is that the individual has to have the ability to be able to vote. And then it also will tell you in there that a person who has been convicted of a felony, if they've completed all of their requirements, that they would be eligible to vote. And I do believe in my reading that the paying of fines is not necessarily included in there. So you'll have to take the protester's document on its face. You ask verification as to how she was proceeding. So taking that into consideration and the information that's provided to you in the guidelines that you've been provided and read prior to, then you have to make a determination as to whether or not he was actually qualified based off all of that information.
I would add that, and as you probably know, I practice law as well, and that's not a qualification for making this statement. But the general process in North Carolina is that if someone has not paid all their fines or satisfied the court, they can extend their probation. And if they extend the probation for non-payment, then that extends the period of time when they have not reclaimed their rights. In this case, the candidate was released from his probation. The fact that there was a mix-up on the amount of fines and when they were paid and when they were not paid apparently did not affect his ability to have his rights restored as a voter. He registered to vote in this county, and I believe I would be correct in saying that at the time, that would have been caught at the time that he filed the candidacy if he were still during his period of probation. We know he was not. He was released from probation. I would like to make one other statement about this and raise an issue. So when you file a notice of candidacy in North Carolina, under the statutes, we have 163-106E. The law talks about the fact that the candidate must, if made clear that a felony conviction need not be first of all, it need not be disclosed if the conviction was dismissed or whatever. But the form shall require a candidate who answers yes to the question of felony to provide the name of the offense, the date of conviction, the date of restoration of citizenship rights, and the county and state of conviction. The candidate did not check the box yes, so he did not provide this information. This information is provided on a supplemental form called felony disclosure form. And that's where that information is asked for, and that is also executed under penalty for false statements, a felony. The fact that the candidate has yet to acknowledge that he was pled guilty to, convicted of a felony, for that reason, he has not filed the supplemental information form. But if this board comes to a finding that he was in fact pled guilty and convicted of a felony, that information is, the public is entitled to that information on the disclosure form that the state provides. And the statute further provides that if an individual does not complete the statement required by this subsection, the Board of Elections accepting the filing shall notify the individual of the omission, that being the supplemental form, felony disclosure form, and the individual shall have 48 hours after notice to complete the statement. If the individual does not complete the statement at the time of filing or within 48 hours after the notice, the candidate's filing is not complete, and the individual's name shall not appear on the ballot as a candidate, and votes for that individual shall not be considered. So I think we also have to consider whether or not the statutory requirement to complete the filing by this candidate has been accomplished. It's clear that the statute, that the statute intends to give this candidate two shots at this. They can either file this information if they checked yes on the box at the time of filing within 48 hours, or if they don't do it, they're given another extension of time when they're notified by the Board of Elections, or in case they weren't aware of the fact that these forms are available, that they have to do it. That we have no evidence that that's been accomplished.
I guess for me, I get stuck on the part where it says a candidate must affirm whether or not they have been ever been convicted. And you said you're not sure. You said best of your knowledge.
Can I ask one more question of the county attorney?
Yes.
And I'm going into more detail because we are, to me, this is a big deal. We're sort of determining kind of not only the fate of Mr. Murillo, but the fate of the race, basically, that he is in. And so I think we're setting a standard. Let's assume that I think that Mr. Murillo was convicted of a felony and that he had not completed his parole or probation. If we make that assumption, but that is not what Ms. Hatcher challenged. She challenged that he lied on the form. Do we still then have the right to disqualify him?
So your response today should be in response to what was filed for the protest. And if she challenged a candidacy, the qualifications for a candidate is that it must be registered in the state, qualified to vote in an election for the office sought, and be of age 21 or older by the date of the election.
Okay, thank you.
So what I would say to you is you have to balance the information by the preponderance of the evidence that was presented in its totality and determine whether or not So the protester's argument was he was a felon at the time and he failed to disclose. Your candidate stated he believed he was not a felon, that he thought he was pled guilty of a misdemeanor, and therefore he did not disclose. So you have to determine what you believe is the accurate, or by the preponderance of evidence, what you believe the result of that should be, and make a decision thereof. You cannot make any decisions beyond what was requested.
Okay.
So, for instance, if this should have been a different type of protest and it was not done, you can't base your decision off of what protest should have been filed and make that decision. You can only go forward based off of the protest that is before you right now.
Okay. Appreciate that.
So Helen, I wanted to ask, the provision I read about if the individual does not complete the statement at the time of filing or within 48 hours after notice, the individual's filing is not complete and the individual's name shall not appear on the ballot as a candidate. That does not require a hearing, and it would not be decided at this hearing. But is that an administrative responsibility, therefore, of this board and the Board of Elections that the individual's name shall not appear on the ballot as a candidate? That doesn't require a candidate challenge, and it's not really the subject of our hearing here today.
So why are we talking about it?
So I would suggest you focus on what's before you today, which is whether or not he was eligible to register as a candidate.
Thank you. I agree. Is there any other discussion? So I think that the facts we need to determine today are, did the candidate plead guilty, or was he found guilty of a felony, first of all? And then, did he complete his felony probation or his probation? And if yes to that question, were his rights restored as a voter in this state? Those would answer the questions that are comprise the subject matter of this challenge. Are you in agreement?
I would agree with you.
Okay. Those are the questions we have to decide on today. By a preponderance of the evidence and the totality of,
I have one question.
absolutely.
Once the board or the director was informed that he had a felony, was he ever given a 48 hours notice? Say, hey, you need to complete, because you were saying he hasn't completed his application. Was he informed that he needed an additional paperwork? Did he ever receive this notice?
Well, he still says that he's not a felon, so.
Well, I mean, if we're looking, we were given evidence saying that this first degree or this lesser charge was a felony. Was he informed of that, telling him, you have 48 hours now to complete the rest of these forms?
No, we give them that form when they file for office.
Okay.
And
So he had the form already.
no,
No.
he said no, so therefore it doesn't print out of the computer.
Okay, so you just.
So it would never
he's-
come to your attention?
No,
if
we
they
take
say
the,
no.
candidate's word.
Right.
Okay.
Thank you. I appreciate that
So,
clarification.
once we got the candidate challenge, that's when we found out about the felony, but then he still wasn't notified. Okay. All right.
Linda, can
And
you?
I think, Bree, from my perspective, if somebody called and said, somebody's challenging your candidacy because you're a felon, if you claim you don't have a felony on your record, then you would probably say, well, I don't need that form.
Yeah.
I don't have a felony.
Which he stated earlier that he was told by his lawyer,
Yeah.
I looked up the public defender, Mr. Floyd, that he was told it was not a felony, so I see your point too, that he believed that he was truthful at that time, that he did not have a felony.
I'm gonna go back to what I was initially talking about. Reading this thing, it says conviction or plead, thank you. And then it drops down to 2, letting you know what the charge would be, assault and battery first degree. So my understanding is that you know at that point what you're pleading to. That's my thinking on it. So I don't get the defense attorney telling you one thing and the judge saying something else. So,
I agree with you, Mr. Edmonds. I think the evidence is clear that Ms. Murillo pled guilty to a felony in South Carolina. I think it's also clear that he finished his period of probation,
yeah, he did.
and that is the practice in North Carolina, that when someone finishes their probation, it's not been extended for any reason, such as non-payment of any costs during that probation or fines, that the person's voting rights are restored. And that is my understanding.
Okay.
I am still concerned that the individual, I will just tell you, I have a concern that he is not able, in his mind, to acknowledge those facts, and that he has not supplied the public, because this felony disclosure form is a public document available for public information and public viewing. He has not completed a form informing the public of the elements of that felony conviction, and his release from the probation and the date his rights were restored. And in fact, we did not hear any testimony from Mr. Murillo about that, because he still believes, apparently, that he did not plead guilty to a felony. It makes it very difficult for the public record and the filing in this case to reflect the facts that we've heard today. And it concerns me because the statute and the disclosure form are intended to provide the public with that information. And but for the challenge presented in this case, the public would have had probably no idea that this offense had been committed in South Carolina, or that there had been a guilty plea by Mr. Murillo. That concerns me. Further discussion?
Can you repeat the three questions?
Yes. The first question is, did the challenge candidate plead guilty, or was he found guilty of a felony? Did the challenge candidate complete his felony probation? And were the voting rights of the challenge candidate restored, and on what date?
Okay.
Linda, can you clarify, you had mentioned the fees and fines that were due and whether that restored his rights. Are you saying that these fees are part of that, the fine, are part of that restoration, and that was done after the fact?
You know, I think that's reflective of a confusion that apparently occurred in the criminal justice system here in North Carolina, where he was serving his probation. As I understand that document, they had assessed him close to or over $6,000 in probation fees because they had improperly entered the term of his probation into the record here, and that in fact the real amount that he owed was the $330. How it happened that he did not follow up and pay his probation fees at the time that his probation period came to an end, I don't know. I would say it's probably an administrative error, and that he has, after he filed as a candidate, made that right. And I would say as a result of this challenge being filed, he became aware of that, and he went and paid what he was then told was the adjusted amount that he owed. And that took place on August 7th, according to the documents we have, after his candidacy papers were filed.
So are we saying that the existing fine that he had, he wasn't informed of that from the courts, so he had no knowledge of it until he went down there? That's what we're saying?
I don't know the answer to that question. He told us that he settled it up on August 7th. That's what he said.
Helen, how does that work?
So you can't assume anything that's not into evidence. You
Okay.
can only go based off of information you've already received.
All right.
Okay, so why don't we answer the questions one by one, and then I think we'll have our answer at the other end.
Exactly.
Okay.
So the first question is, did the challenge candidate plead guilty, or was he found guilty of a felony?
I think you can clearly say yes based on this document.
I think so too.
Yeah.
Is everyone in agreement on that?
Yes.
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 Yeah.
The second question is, did the challenge candidate complete his felony probation? And what is the feeling of the panel members on that? What is where do you fall on that? Irene, you want to start?
No.
Oh,
I'll start. Yes, he completed them afterwards.
after what?
So you think he completed probation after filing?
After filing.
Okay.
I'm inclined to say yes, he completed his probation, that his rights are restored. Confusion, whether the payment of this fine is a decision to be used in this. I've heard conflicting from the attorney saying that that doesn't preclude him from getting his voting rights restored if there's an outstanding fine, but his probation was clearly finished. His probation time was clearly finished.
So what I can read for you, which is currently on the North Carolina Board of Elections website, and I have a copy of it as well.
Okay.
So for registering as a person in the criminal justice system, it says voter eligibility for people serving felony sentences. Once a person is convicted of a felony, they lose the right to vote in North Carolina until they have completed their sentence. This includes completing any aspect of their sentences in prison or jail, as well as any period of probation, post-release supervision, or parole associated with a felony. It goes on to say that once their period of supervision is over, a person convicted of a felony automatically regains the right to vote. They must still register to vote, even if they were previously registered to vote prior to being convicted of a felony. It says having financial debt associated with a felony sentence, for example, fines, fees, or restitution, does not necessarily make someone ineligible to register or vote.
It's not necessarily.
So that's a big maybe.
It says someone can have their probation period extended due to a failure to pay such a financial debt, in which case they are still not eligible to vote if the probation obviously is extended. However, probation can and does end for many people with a remaining debt. If a person's period of felony supervision is over, they regain their voting rights, even if they have remaining debts associated with their sentence.
And that's my
And then I
understanding
have
as
a hard
well.
copy of
Thank
that.
you.
And that's
That
my
helps.
understanding as well, that it was up to the probation system to extend his probation if he had not settled his debts.
So with that clarification, I would say yes, he finished his probation. Ryan?
Based on what she said, I'd have to agree that his rights were restored, even prior to the fine being paid.
Do you wish to make yours now?
No.
Was there a third question?
Yes. Are we in agreement on that? Or are you still?
No, I'm still not.
Okay,
Yeah.
that's what we're
I'm-
allowing time for.
So the question that we're talking about right now is whether his rights were restored. Is that what we're on?
We're on whether or not he completed his felony probation
Right.
and whether or not his rights have been restored.
Okay.
I don't recall.
Yeah, so go on to the next question. Let me
Those
stew
are
on
the
this
three
for a minute.
questions. The
Okay.
first was
Question.
whether he was convicted or pled guilty to a felony. The second question, Did the candidate complete his felony probation? Third question, were his voting rights restored, and on what date?
I don't recall a document that says his stuff is restored, his privileges are restored. The only document I saw that might indicate that at all is a receipt saying it's paid, but afterwards.
Well, there is no such document. When we were at training, remember?
Yes, they stated that once, the attorney stated that once the probation is finished and they completed all their obligations, their voting rights are automatically restored. You don't need to go somewhere and get a statement or.
Don't
Yeah.
get a big old pretty certificate
No,
saying.
Paul
No, you don't.
Cox, as a matter of fact, Paul Cox said, if you're
Yeah.
expecting some sort of piece of paper that says somebody's rights are restored, then think again, because that's not going to happen.
Do we have any evidence in the record today of when his felony probation ended?
Well, 3 years, right?
I don't know. I'm asking the question.
It says 3 years, but once again,
But it can be extended when there's non-payment of fines and costs.
don't have that information.
But it doesn't look like anything was extended.
So what now?
It doesn't look like anything was extended. It looks like this was it, and the court said, that's it. I don't see any other paperwork saying there was an
I
extension.
agree with you. I think he would know if he were still under
Yeah.
probation. Of course, there's
Well, he didn't know if he was,
informal probation as well as
he didn't know if
supervised
he had a misdemeanor or a felony, so
probation. I understand. I understand.
I'm just saying.
So it says, yeah, he had 3 years and then 1 year suspended probation. I think that, and that's been way over.
What we know is that this occurred in 2012, that the
Right.
plea was made in 2012, and this is 13 years later.
Yeah.
The supervised probation would have ended unless it were extended for non-payment of fees, and we have no. But do we have any document or testimony? Well, we don't have any testimony from the candidate that his rights were restored because he believes he never lost them.
When was this challenge filed? Does somebody have a date?
It's on the 24th, July 24th. So at a minimum, according to the felony disclosure form, at a minimum, the public is entitled to know the date the citizenship rights were restored. Apparently,
So I do
Candidate
not,
doesn't know that because they don't believe they lost their,
I don't have the documents that the protester or challenger provided to you all, but I would suggest you could probably look at that, and where it talks about fees, it should also say whether or not, it should give you some indication whether or not he was still on probation
the records that were.
that you received from the challenger.
The documents that we received from the challenger say that he was released from probation in 2017, 5 years after he entered probation, which does not obviously coincide with what we understood the sentence to be. I don't know, that means that the probation was extended for periods of time. But it's also inaccurately assessed the probation fees
So-
for 5 years,
So you said that the document said that the probation ended when?
2017.
Okay, so,
Where did you find that?
It's in the
That's what the
protest that was-
challenger-
It was in the challenge that was originally filed, the challenger.
Yeah.
so your question was whether or not he's still on probation. You just stated that the document showed you that it ended in 2015.
Well, that same document assessed fees of $6,000, which he didn't owe. And the candidate has
And
done,
I understand that you had the candidate as well as the challenger testify as to that. So I think you used the evidence that you had before you to answer those questions.
okay.
The document says 2013. Probation ended 2013.
I think we're referring to different documents. So. The point is, it's
So
been 13
I would just
years.
suggest that you identify which document that you're referring to. I think you have certified copies of some
we
documents,
do.
and you have some documents that may not be certified. You accepted them all into evidence, so whenever you're referring to the evidence, please identify it as either the challenger or the candidate's documents.
We have a letter from the North Carolina Department of Adult Correction indicating that their supervision ended in 2013, the supervised probation. Does that tell us that probation ended entirely? Because there was supervised and unsupervised probation.
So if it states that he was, his supervised probation ended, and it does not tell you that he went on to an unsupervised, then I would suggest in my practice
Experience.
history, then all probation ended.
Okay, thank you, I appreciate it.
But again, recalling back to what was previously read, that fines could be different from continuing on with probation unless you have something specifically stating such.
Correct, and it's my understanding that if someone still owes restitution or fines, often their probation is extended for that period, for some period of time, and that did not happen in this case.
So there are a lot of different things that can happen if fines aren't paid. That's one scenario. But also sometimes fines could be made into a civil judgment or different other
sure.
things. So you can't assume, but your document does not provide you any information of an extension.
No, I was not suggesting that we should assume that they were all paid. We know, in fact, they were not. What I'm suggesting is that the probation was not extended for the non-payment. We have that information in this letter from,
So you use the evidence that's before you.
I have to tell you that in the front of my mind, I have the question of when does this candidate acknowledge to the public through a felony disclosure form that's required, lest he be removed from the ballot? Because he's not acknowledged that to us today, and he's testified, I'm sure, under oath honestly, that he believes that's not the case.
But that's not what we have to decide.
I understand that. The questions we have to answer today in this proceeding, in this hearing, based on the challenge that Ms. Hatcher presented, was whether the three questions we've discussed, whether he was found guilty or pled guilty, whether he completed his probation, and whether his voting rights were restored. That would make him eligible to file a notice of candidacy.
The main question in my head is on what date were his rights restored, if they were restored. Because if his rights were restored before filing ended, then he had the right to file. If his rights were restored after filing ended, then he did not. I think we all agree that he was convicted of a felony and that he was less than truthful about that felony. The question is, what do we do from there? Because if his rights were restored before filing ended, then he has a right to run, whether any of us like it or not. If his rights were restored after filing ended, then he doesn't have a right to run. Again, whether we like it or not. So that's the big question in my head.
I am satisfied that his rights were restored before the filing, despite the fact that he paid the probation fees not until August 7th, which would have been last week. we have no evidence from the challenger that would contradict that information, which she provided in her challenge documents, that his probation ended at the very latest in 2017. How about you?
I already made my statement on it.
What was your statement?
My statement is, all right, he was finished in what, 2013, which we do have on the paperwork. His fees were not paid. We have answered the questions on all three that he has met the requirements, like it or not. That's where we're at.
So I think what you're saying is, first of all, do we have agreement on the fact that he pled guilty to a felony?
Yeah.
Yes.
Are we all in
Yeah,
agreement?
we all agree on that.
Do we all agree that the candidate completed his felony probation?
Yes.
Don't
Yes.
know. No clue.
You're a no.
No, I don't know.
It is a, I don't
I-
know, but
I
it
don't
says
know.
that he finished his supervision
Right.
on 2013 with unpaid, with a balance
Right.
to be paid.
So the third question then is, were his voting rights restored?
And
If
when?
If with what the attorney has said, then at 2013, yes,
They were.
it
Yes.
was restored.
I say his voting rights were restored.
Are we ready to make a decision? We have to, this is a majority vote, it does not require a unanimous vote. It sounds as if we have a consensus that will get us to a decision point. Is everyone ready to vote?
As we can just keep going
May
around
I,
that.
may I ask a question about that too? Is, if we are saying that his rights were restored, but we're also saying that he's convicted of a felony, he has to fill out the form that acknowledges it to the public. Is that correct?
It's my understanding that if he does not fill out the felony disclosure statement, that his name cannot appear on the ballot and votes for him cannot be recorded.
I agree with that.
So that's a form that he has to fill out to release it to the public, letting them know that, yes, based on this form that we see right here, he was convicted of a felony.
I think, and this is probably a question for Angie, if we decide today that he was convicted of a felony, then Angie, you would have to give him the form to fill out? Is that
He
the
has
case? And then he
48
has
hours.
48 hours to return it to us.
Actually, I believe we can give him that notice today. I have a copy of that form with me today, and I believe he would have, that he should, as soon as possible, and within 48 hours, complete that form,
I think Angie has
which would
probably.
require him to affirm under oath his
You
felony.
probably have it with you too, don't you?
Which would require him to affirm under oath his felony conviction and information that the statute requires.
You're a good director.
So are we ready to vote on the challenge, which is the subject of our hearing today?
I think we are.
Yes.
Based upon the preponderance of the evidence and the preponderance of the evidence and the totality of the evidence, I would ask for a vote now on those who are voting for to acknowledge and approve the challenge presented by the challenger today. Voting affirmative on this question would remove the candidate, and I'm asking whether or not you believe that the candidate did not meet his burden of proof. And I guess that's really the question we should vote on first. Do
So
we
I
believe
think
that
your
the
question is going to be whether or not the candidate
met his burden of
proved
proof.
by a
Yes.
preponderance of the evidence
Yes.
as a whole that he was eligible. So
Yes.
that's probably the cleanest way for you to answer that question and decide that, whether or not the candidate has provided enough evidence based off of the standard of by a preponderance of the evidence of all the evidence he submitted, that was submitted, that he was eligible to submit his application as a candidate.
So the question for us to answer is whether by a preponderance of the evidence and the greater weight of the evidence, whether or not the challenged candidate was found guilty or pled guilty to a felony, whether he completed his felony, and whether or not his voting rights were restored. And I ask for your vote on that in the affirmative. It is his burden of proof. If you agree that he has met those qualifications, please indicate by saying aye.
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 No.
Those opposed? And that is a 4-1 vote, and that is a majority vote. And Mr. Murillo, this panel has found that your filing, that the challenge to your filing has not been affirmed, that you remain a candidate for the office of City Council District 5 in the city of Fayetteville. I want to also advise Ms. Hatcher and any candidate adversely affected by the panel's decision today that they have a right of appeal to the State Board of Elections, that a recording of this proceeding will be forwarded to them for that purpose. This appeal must be taken within 2 business days after the panel serves the written decision on the parties. We hope to have that written decision ready by noon tomorrow. And with that, if there's no further business to become for this panel, I will ask for a motion of adjournment.
I have a question.
Yes.
Where did this document come from?
It was, the template for that was provided by the State Board General Counsel.
Okay, because the first time I saw that was, I think, last night or possibly this morning. I mean, I am not an attorney, so I like to prepare for these things.
It was provided, I provided it to our staff, I believe early Monday morning or Sunday evening. And they sent that to the parties and to the board members as soon as
Not
they
to the
arrived
board
at
members,
work.
because
Did you get a chance to look it over?
it's the order of proceedings.
Yes, I sent that to her over the weekend. Both the general counsel for the state party as well as Helen reviewed it and said that it was a good document. That's what we should proceed with. It was on their advice that we,
Everybody's and I think I responded, and I believe that Chair DeVore was not on that response. And then I forwarded it to her, but
Okay, all right.
I do believe everybody, I know I reviewed it and I responded to it.
general counsel for the state party as well as the county attorney's office was in the loop on that and gave us the go-ahead on that. So if there's nothing more to come before this board, I would ask for your vote on the motion to adjourn. All those in favor of adjournment signify by saying aye.
Aye.
So much, everyone.